SJC-13190, Commonwealth v. Dario, Baxter.
Okay, Attorney McDonough.
Thank you, Your Honor. Good morning, Chief Justice Budd and Associate Justices. My name is Jaleese McDonough and I represent Dario Baxter. The evidence presented in the first trial in this case is lower than this court has ever deemed sufficient under Lattimore, relating to both identification and intent. And because the evidence was insufficient in this case, we're asking that you bar the Commonwealth from retrying Mr. Baxter in a second trial. I addressed my issues in the reverse order in my brief, but today I'd like to start off with addressing the insufficient evidence relating to identification, and then address the intent relating to first-degree murder under a joint venture theory.
Your client's fingerprints are inside and outside the car. It's his girlfriend's car that he drives. She's not driving it because she's punched in at work. And there's some photographs. And why is that not sufficient to reach the jury? I'm not suggesting that it's a slam dunk case. Obviously, there was a mistrial in the first case, but why is that, not sufficient?
Yeah, sure. As to the fingerprints, the car was seized a day and a half after the shooting, and there was definitive proof that Mr. Baxter had been driving the car about 15 hours after the shooting. And there's no evidence to suggest that the prints were put on the car at the time of the shooting rather than later that evening when Mr. Baxter.
Just before you go into that, can I ask you to apply the legal standard, right? Viewed in favor of the Commonwealth, the light most favorable to the Commonwealth. Why is, and you're presenting defenses, my fingerprints were there because I have access to the car regularly, I had access afterwards, but that's not viewing it in the light most favorable to the Commonwealth. Can you do that?
Yeah, sure. I think even viewing it in the light most favorable to the Commonwealth, drawing all reasonable inferences in favor of the Commonwealth, it's still not enough. I think it's similar to this Your Honor's decision in Anitis and also Davis. The court has to look at whether the inferences that the photograph was Mr. Baxter is reasonable. In taking the evidence in its totality, they have to put Mr. Baxter behind the wheel at the time of the crime. There's no one who puts him anywhere near the crime or in the vehicle other than this one still photograph that the Commonwealth suggests resembles Mr. Baxter. So even taking all of those reasonable inferences in its totality, it wasn't sufficient to prove that, one, it was Mr. Baxter at the time and that he was behind the driver's seat at the time that the shooting occurred.
Well, we can also take into account where his co-trainers were dropped off after the training session downtown in the direction in which they walked, in conjunction with everything Justice Wedland just laid out.
Yeah, sure. And I think even assuming that the vehicle was Miss Rayner's that was observed in the surveillance footage, that doesn't bring it over the Lattimore standard. As this court said in Gonzalez, people let other people borrow their car all the time, and it wasn't even Mr. Baxter's car, it was his girlfriend's, and there was no evidence before the jury that Mr. Baxter was the only person she would allow to borrow the vehicle.
Well, if you segregate all these potential inferences, clearly you're not going to satisfy Lattimore, but it's the synergistic effect of all of them, including the tint being removed shortly after the shooting. But I had a chance to look at the surveillance and the manner in which the car was being operated right before and after the shooting seems to indicate that the driver has a shared mental state. I won't go all over it, but clearly you've got following of the individual on Ross and Wayland Street, pulling ahead and pulling over, waiting, and then the shooting, and then driving away. And when you look at the surveillance tape and you see the manner in which this car is being operated, it's hard to see why you couldn't infer a shared mental state from that.
Your Honor, I think you would need more than just the maneuvering of the vehicle. I think it's similar to Gonzalez in the fact that there was some maneuvering of dropping people off, turning around and leaving the scene. But even this court said in that case that even if you can infer the knowledge of the driver under those circumstances. We still don't know that there was the lethal intent necessary for first-degree murder. We don't know whether, even if the driver knew that he was dropping someone off to interact with Mr. Ross, that it was to use a firearm and shoot him. The Commonwealth seems to suggest that the only reason you would pull down a side street and allow the person to return to Wayland is because the person has a gun, but I think that's too far of an inference to draw.
Well, they waited on the side of the road, relocated, waited on the side of the road for the victim. And then shortly thereafter, there was a shooting, and then the civilian witnesses saw the running, and they entered back into the car.
I'm not sure that we can say definitively that they were even pulling to the side of the road to watch Mr. Ross pass by. I think even that is based on speculation. There's no evidence that Mr. Baxter or anyone in the car even knew Mr. Ross. Mr. Ross was staying at someone's house that no one even would have known he was there. It was a secret relationship. So there's nothing leading up to the actual incident to suggest that they were looking for Mr. Ross, that this was a planned encounter, and that it wasn't just a happenstance. They had pulled down the street and someone in the car said, "Stop, I want to get out." And you know, this court said time and time again that if there's two conflicting inferences that can be drawn from the evidence, it's just not enough to get over the Lattimore standard. Even pulling down the side street, we still don't know whether the driver knew there was going to be some sort of encounter, but didn't know whether any of his passengers were armed, which this court has said in Commonwealth versus Britt that there's no requirement that he know his co-defendants are armed, but it is one factor to suggest that he may not have known this was going to be a deadly encounter, even if he knew the circumstances surrounding it. That it wasn't just a situation where they were going to jump someone or have a drug deal or something other than the intent necessary for first-degree murder. And as to the other factors that the Commonwealth's pointed to, so the fingerprints, there was evidence that Mr. Baxter was driving later that evening, so they weren't necessarily placed on the vehicle at the time of the crime. And Mr. Baxter did admit to driving Ms. Rayner's vehicle from time to time, but he specifically denied driving it on the morning of the shooting. So taking all of these factors, this court in Davis specifically said that an unclear video, unclear surveillance stills is not enough to draw the inference that it was the defendant driving. And even in that case, this court said it was a close call, even when there was GPS device putting the defendant at the scene of the crime, tracking his movements on surveillance after the fact. And the evidence here fell far short of that, just putting Mr. Baxter behind the wheel at other times other than the time of the shooting. So given the totality, our position is that the Commonwealth failed to present enough evidence to prove that Mr. Baxter was the driver at the time of the shooting. And even if this court does find that that was sufficient to say that Mr. Baxter was driving, it still doesn't prove that he had the intent necessary for first-degree murder. As the court noted, the evidence that the Commonwealth essentially points to is the maneuvering of the vehicle, that he pulled down Wayland Street, pulled over to the side of the street, and then pulled down Balfour Street and parked. But even looking at the absence of some of the maneuvering, there's no evidence that even if it was Mr. Baxter who was driving, that he sped away after the fact. Exhibit 6, all of the camera angles show that the car was driving at a reasonable rate of speed after the fact. There's no evidence to suggest that even if Mr. Baxter was the driver, that he knew anyone in the vehicle was armed. All of these cut against a finding that he had the intent.
What do you do with the evidence that your client was pulled out over actually in the vehicle the evening after the shooting, and that Mr. Wright was in the car at the time?
Yeah, sure. I mean, that was 15 hours later. I don't think it's some evidence that he drove the vehicle at times, but it still doesn't place him in the vehicle at the time. There's no suggestion that they were wearing the same clothing that the Commonwealth alleged Mr. Wright was wearing that morning, or in the video when they claim they could see through the sliver of the window. So it at least suggests that there had been some time that had passed, that they weren't in the vehicle that day. And even I think one of the justices had raised the point of the window tints. Mr. Baxter was specifically instructed during the stop that one of the reasons for the stop was the tinted windows. He told the police that the vehicle had been frequently pulled over for tinted windows. So that someone removed the tints the day after that there was a stop again for tinted windows leads to a possible inference that it has nothing to do with the vehicle being involved in a crime. And even if Ms. Rayner was removing the tints because she believed it was involved in a crime, it still doesn't put Mr. Baxter in the vehicle at the time that it occurred. And this court outlined 3 kind of overarching circumstances the court should look to on deciding whether the mental state's there for a driver in Gonzalez. So the direct evidence of the defendant's mental state, evidence that the defendant acted in a way inherently demonstrating lethal intent, or the defendant heard the perpetrators express lethal intent. None of those factors are present here, or any other evidence other than the maneuvering of the vehicle to suggest any sort of intent on behalf of Mr. Baxter. There's no evidence he provided a firearm to anyone in the vehicle, that he made threats, or that he made any admissions after the fact. There's no evidence that he observed anyone in the vehicle demonstrating any sort of lethal intent. So I think the closest cases to this incident are Commonwealth versus Stewart and Commonwealth versus Kilburn. And there was
Well, do you want to distinguish Commonwealth versus Watson though?
Yes, Sean, I would be happy to. So in Commonwealth versus Watson, there were hundreds of calls between Mr. Watson and his co-defendants leading up to the incident. He was at a party that the victim was actually at beforehand, and there was video footage showing that they engaged in reconnaissance beforehand. So Mr. Watson was then alleged to have driven Mr. Robertson to the scene, actually blocked the street so that no one else could get down the street. And on video, it seems to suggest that he was able to witness the actual shooting as it occurred. So all those circumstances show that he had knowing participation, given that he had had so many conversations with the co-defendants. There were calls, I believe, leading up to just seconds before Denton and Bonner fired shots. And then immediately after Watson pulls up with Robertson in the vehicle, he gets out and fires shots. So given that he had blocked the street and was personally involved in reconnaissance and fleeing, there was far more evidence demonstrating intent than in this case. And even his actions after the fact, he fled his vehicle, he left his cell phone in the car. None of those circumstances are present here. And as to Stewart and Kilburn, most of the evidence in those cases also dealt with just the maneuvering of a vehicle, driving a co-defendant away from the scene. And even in those cases, there were at least some circumstances beyond just how he drove the car to suggest he had the intent. In Stewart, the defendant actually watched his co-defendant shoot a cat earlier in the day. He fled away from the scene. He collided with other vehicles to suggest knowing participation. And in Kilburn, he actually pulled down an alleyway out of view of spectators and any witnesses in order to make a quick getaway. The driver here is alleged to have been parked on a public street around the corner, and there's no evidence that he knew anyone in the vehicle was armed. So our contention would be that the evidence here, it fell short both on identification and intent, and that the Commonwealth failed to prove those elements to the court. There's the other factors this court's looked at, in Jones and Watson, as I had mentioned. There's some evidence putting the defendant at around the scene. Eyewitnesses saying that the defendant met the description of someone at the scene, GPS, CSLI, even phone records suggesting that there were calls between the co-defendants to engage in some sort of planning. The only thing we have here is that even if Mr. Baxter was the driver, that he was in the vehicle for a few minutes beforehand, that they drove over to the area of Wayland Street with no suggestion he knew who the victim was, that there was any sort of plan, and that at some point someone got out of his vehicle without any suggestion that he knew what was going to happen if someone got out of his vehicle. So just viewing the totality, the Commonwealth did not present sufficient evidence at the first trial to be entitled to try him again without violating his right to be free from double jeopardy. So if the court does not have any additional questions, I cannot rest on my brief. Thank you, Your Honor.
Thank you. Attorney Doherty?
Morning, Chief Justice Bud, and may it please the court, Andrew Doherty for the Commonwealth. I'd like to first acknowledge several individuals who are watching the live stream of this, including ADA Tara Birdman, who's the trial attorney, as well as several family members of Michael Ross, who is the victim of this case. Viewed in the light most favorable to the Commonwealth, the evidence established that the driver of the car was integral to setting up and fleeing from an ambush murder. And in fact, in looking at the different steps that this driver took, the only thing the driver really didn't do was pull the trigger here. He brought the shooter to the scene. He then moved the shooter to a place where it was far easier for him to approach Mr. Ross unawares as he crossed the street, and then remained there after the shots were fired. It's reasonable to infer that he heard that the shots were fired and then did speed away. And there was several witnesses who observed the car speeding down Balfour Street in order to leave the scene. It taken all together, that it is clearly sufficient to infer that the driver had the requisite knowledge, the shared intent of his passenger in order to get us over this hurdle.
Mr. Doherty, I get the identification based on the photograph and the like, and I get the participation part of it. But how do we get to lethal intent? It's an ambush, but isn't it equally possible that they're trying to beat the guy up? How do we get the lethality to prove joint venture?
Sure. So first of all, I think positioning, the fact that the driver remained in the car shows that he knows, he's well aware that this is going to take one person to do it. And positioning the car in a way, if this was just going to be, not that we have to rule out other inferences, we just have to show that it's a reasonable inference here. But if they were going to beat him up, why not beat him up as he passed them on Wayland Street? Why not bring 3 people to a fist fight instead of remaining in the car, able to flee?
It just sounds speculative to me to say that, you know, if it's going to be beating someone up, it's one-on-one. It would be more than one-on-one, and if it, because we have no threats. I mean, in Watson, he pulls up as the guy shooting him. I mean, and there's a reconnaissance. This seems to me like Gonzalez, not Watson. I mean, I'm trying to reconcile beyond speculation that it was going to be a shooting. The first time that we have evidence a gun is wielded is when the guy gets in the car. We have no beef, or at least there's no evidence of a beef, right?
Right. Right. We don't know the why of this, but we do know the how of this.
Right.
And I would look to the fact that he does. It's not enough that he is right next to the victim as he's walking up Wayland Street, but that he then, I guess, decamps to a more strategically advantageous position on.
Well, I agree.
Street.
I agree. If a light most favorable, we have an ambush. But I'm just trying to wrap my arms around, beyond speculation, what makes a lethal intent, which is the crux of the joint venture doctrine that you espouse.
Sure. I mean, it doesn't get more. It doesn't get more clear than the fact that he remains in the car while the shooter leaves, ready and able to leave, and then the shooter comes back. And what I would add to that is,
so you want us to infer that if it was going to be a fight or a beat down, it wouldn't have been a one-on-one.
And that the driver wouldn't have needed to move to a more strategically advantageous position, which was about 3 house lots down from Balfour Street.
But why? It's an ambush. Couldn't he just be jumping them?
I think we're not talking about equal interest, so that we're guessing which one it is. I think it needs to be, what we need to show is that the inference here is reasonable and
Right.
the product of common sense. And I do think it is,
and not beyond speculation.
right. But I do think that the distinction here and where the evidence shines the most is that they did remove themselves to a position where they could have just as easily jumped this guy to a position where he was able to approach within a matter of a few feet. But
you're making do with the evidence that you have, and you try to draw all reasonable inferences. I'm just wondering if that evidence is enough, but I guess we'll see.
I have a question on that point, if I could follow up, Justice Graziano.
Yeah, I'm done. Thank you.
And that is, what is the evidence in the record, or that you can, that was in the last trial, that that your client knew there was a weapon involved, or that the co-defendant had, the joint venture had a gun?
I think it's twofold. It's that he was in a position where he was down the street and the shooter could approach within a close distance, which to my mind rules out and makes more likely the inference that it was going to be a shooting rather than a beatdown, where they just need to be close to each other, where there needs to be multiple people there. And the fact that the defendant remained in the car as the driver and let the shooter do his work before he came back. That makes it a more likely and reasonable inference that this was going to be something fast and deadly, and that he was not necessary in order to make sure that this happened the way they wanted it to go down. Where I would add to that is bearing in mind that you look at the totality of the evidence, here's a case where all of the circumstances that led to the shooting were generated by the driver himself, this defendant, where getting the person into the right position, doing the observations, moving to a place where there was a better position to make this attack happen, and then sticking around, all of those things were the result of the defendant's actions. And when he created all these circumstances, to then, I think it's reasonable, looking at the whole of the evidence, that there was enough to then find, yes, of course he knew that it was a gun. He was the one who brought them there. He's the one that observed the victim walking up the street and moving to another place. The only thing, again, he didn't do is pull the trigger himself. And I think that—
Mr. Doherty, can you draw an inference at all from the fact that there was a pickup after a shooting?
I think you need to look at the entirety of it. And yes, that certainly was a part of it. Where there really is a single plan here. Once the car turns over, it turns onto Wayland Street, that period of, say, 2 minutes is all orchestrated in order to shoot Michael Ross.
But isn't the issue there that it lapses into accessory after the fact? Because to have joint venture, you need at the time of the murder shared lethal intent. Accessory after the fact speaks to an intent to assist someone, obviously after the crime is committed.
Well, he's charged with that as well. What could this be but a planned ambush? And if it's a planned ambush, is it not?
No, I'm with you on planned ambush. The question is what kind of an ambush? And that's where I'm struggling to see the lethal intent.
Right. Well, I
absent of beef, absent all the other evidence we've had, because we have a bunch of getaway driver car cases.
Right. Which I again, those are cases where it's a getaway driver. I'm sorry.
We've never said the fact that you're a getaway driver means that you share the intent of the shooter. You need some other evidence apart from the action.
Right. But he's not just a getaway driver here. He's also sort of a get him in the right position driver. And there is no better position for this shooter to be in.
I thought every getaway driver gets them in the right position, but that might be me.
I think that, sure, if he just dropped him off, right, like in Mandil, where he just drops him off and 10 minutes later there's a shooting, this is a far different case. This is a case where they're in the location. They go to a better location that's even better for shooting.
I agree with you on that. That you know, the fact that he facilitates the ambush is different than the Mandiel drop off. I get that.
Right, and I suppose that you know, one thing I would point out, you know, where Gonzalez identifies 3 examples of where intent can be inferred. It certainly wasn't an exhaustive list, and I do not think it is a far cry from Gonzalez to also find where the driver was aware of and a part of every step of the plan leading up to the shooting and then after the shooting, that it's reasonable to infer that he knew this was going to be a shooting, which may be a small step away from where the current case law lies. I'm not saying the court needs to do that in order to make this decision in the Commonwealth's favor, but it seems in keeping with the state of the law as it is. Unless there's any questions about identification, I did want to point out, in addition to the videos that I referenced in my brief, that there is one additional video. Exhibit 5, if you start at the 2-minute mark, you'll be able to see another camera angle that was of evidence from the brick cameras that shows, perhaps in a clearer way, what happened here. And finally, there are 2 instances in the interview of the defendant where he says he has permission to use the car, but also the only other person that has permission to use Khadijah Wright's car is her sister. And other than that, I suppose I would rest on my brief.